Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am Executive Director of the Washington Legal Foundation, and I'm also the Vice President of our Legal Studies Division. For those of you not familiar with the foundation, we are in our 48th year of free enterprise advocacy and education through litigation, regulatory comments, publishing, blogging, and doing programs such as this one. If you want to take a minute and check out our website, wlf.org, and we're through with this, learn a little bit more about us. So about 7 months ago, when the temperature in DC was at least 50 degrees colder, we hosted a preview of the Supreme Court's upcoming oral arguments in 7-county infrastructure coalition versus Eagle County. We had a panel of outstanding speakers, and they had such a good time doing it with us that they said they'd be happy to come back and talk about it once the decision comes down. So now the court's issued its opinion in unanimous form, we're pleased to get the band back together for this particular webinar. Even though the outcome was unanimous, the opinion has many layers and twists and turns. So we got a good amount to cover. Going to get right to introducing our panelists, and then we'll get started with the conversation. Mario Loyola is a research assistant professor at Florida International University and director of its environmental finance and risk management program in the Institute of Environment. He teaches administrative and environmental law at the College of Law. He's also a senior research fellow at the Heritage Foundation, and he's a former associate director for regulatory reform at the White House Council on Environmental Quality. Christopher Thomas is a partner in the Phoenix, Arizona office of Holland and Hart. He focuses on complex infrastructure permitting, natural resource and hazardous substance litigation, environmental defense, enforcement defense, and site remediation. Chris is an elected fellow of the American College of Environmental Lawyers and a frequent writer and speaker on environmental and natural resource topics. Chad Whiteman is Vice President, Environment and Regulatory Affairs with the U.S. Chamber of Commerce's Global Energy Institute. Before joining the Chamber, Chad was Deputy Chief of the Natural Resources and Environmental Branch in the White House Office of Information and Regulatory Affairs, better known as OIRA. He also previously served at the U.S. Environmental Protection Agency, developing and implementing clean air policies. So a reminder to our audience that the program is being recorded. If you have any questions for our panelists, you can ask them at any time during the program using the Q&A function in the Zoom webinar toolbar. So we'll get started. Chris, in all your years practicing environmental law, can you remember a majority opinion from the Supreme Court on an environmental case as strongly worded as Justice Kavanaugh's opinion was for the court in this case?
Certainly not that I can recall, and it was kind of enjoyable read for those of us that have been frustrated with NEPA delays over the years. And it's kind of like the Big Lebowski. There's all sorts of parts in there that are fun to quote, depending upon your perspective. But I think the concurring justices pretty much said, we could have just decided this case by reaffirming public citizen and holding that regulatory agencies need not evaluate impacts they have no authority to regulate. But Justice Kavanaugh clearly thought that courts of appeal and district courts had not gotten the message that deference is indeed the key byword under NEPA. So it was a pretty good rebuke of both the courts and to some extent litigants. There's one passage 20 and 21 in the slip opinion where Justice Kavanaugh said NEPA has transformed from a modest procedural requirement into a blunt and haphazard tool employed by project opponents who may not always be entirely motivated by concern for the environment to try and stop or at least slow down new infrastructure and construction projects. I mean, that's pretty pointed criticism of people that make a living with NEPA litigation.
Mario, what are your thoughts on the sort of tone and language of the opinion, and how much of it do you think it had to do with the substance of Justice Sotomayor's concurrence for 3 of the justices?
Yeah, great question. I mean, what I have been saying to this on the question of, is this a historic NEPA decision? Is this going to change? Is this a sea change in NEPA? And I think the answer is maybe. And the maybe is that it depends on how lower courts are going to apply this case. Because what Justice Sotomayor did in her Justice Sotomayor's concurrence boils down to nothing to see here, right? And so if the courts there is a possibility that that lower courts will just say, yeah, there's nothing to see here. This is how we've always understood NEPA, and we've always, because of course they've always paid lip service to deference, right? For decades, courts always say that they have to defer to agencies. That's like their ritual, profession of faith to deference, which they always profess right before they don't defer to the agency. And the lower court did that in this case. The DC Circuit did that in this case. It made this protestation of how they need to defer to the agency, and then it just started disagreeing with fire hazard assessments by STB, something that the court knows nothing about, and which is in the expertise of the agency. And then, meanwhile, after not deferring to the agency on the stuff that is within the Surface Transportation Board's jurisdiction expertise, then it went on to say all the things that the Surface Transportation Board didn't discuss that it should have discussed, that are entirely outside of the Surface Transportation Board's jurisdiction and expertise. And so I think that this really highlights, this really highlights that the search for the limiting principle on downstream and upstream impacts that need to be studied under NEPA. There is an end to the rainbow, but the end to the rainbow is not in NEPA. It is in the Administrative Procedure Act, and it specifically its scheme of deference doctrines under Section 706. Because, as the court itself said in West Virginia versus EPA, I was very surprised that it didn't quote this dictum from West Virginia versus EPA. But if a particular issue is not within, I think the quote is something to the effect of, if a particular issue is not within a agency's jurisdiction or expertise, Congress would presumably not have required the agency to study it. There's like some sentence to that effect in Roberts' opinion in West Virginia versus EPA. So is it a historic decision? Maybe not. If the courts take Justice Sotomayor's approach, there's an asterisk here, however, because even Justice Sotomayor's approach leaves the Sable Trail decision in the DC Circuit very much on thin ice. And so I hope we can get to that in a second. But on the deference side, I think that the strongest chance for this to turn out to be a historic milestone sea change in NEPA, in the jurisprudence of NEPA, is if lower courts view this as the other side of the coin from Loper-Bright, right? Loper-Bright said, wait a second, we've been too clever by half here. There's all this step zero and all this stuff. But Section 706 says courts decide questions of law, right? That is the core competency of courts. So we're going to go back to it's the province of courts to say what the law is, not the agencies. Well, this is the other side of that coin, arguably, which is it is the province of agencies to make technical judgments. It's the province of agencies to make policy judgments. And so that is something that that we have needed just a general reaffirmation of. And in keeping with, a court that has Justice Gorsuch and others and Kavanaugh on it, we're going to see potentially this trend in opinions that restore the separation of balance and that are more respectful of the separation of balance. And then, so I would say the key here is Justice Kavanaugh is demanding that courts defer to what? Courts defer to agencies' determination of what impacts to study under NEPA, what alternatives to study under NEPA, and how much details to study them in. And why is that potentially impactful? Well, because those three things are the source. If you want to know why EISs are 3,000 pages long, it's because agencies do not expect courts to defer to them on any of that. And so they are studying all the alternatives they can think of and studying all the impacts they can think of and studying in them in as much detail as the taxpayer can possibly bear at the end of his taxpayers' limits to pay for the government, just $15 million or $20 million for an EIS. As you can see, I get exercised over this. And if it's true that, this is a real correction, no, courts really have to defer to the agencies on what impacts they want to study under NEPA, what alternatives are relevant under NEPA, how much detail to study them in, then we could be going back. I mean, agencies could say, okay, let's go back to 100-page EISs, and we just expect courts to defer that our technical judgment in doing a 100-page EIS was valid. And if that gets sustained, then there is your sea change in NEPA.
Thanks, Mario. So, Chad, U.S. Chamber Litigation Center filed a brief on behalf of the chamber and 9 other organizations. Did you feel comfortable and pleased with how the court's opinion came down in terms of whether it tracked with what the arguments of that the chamber made?
Yeah, certainly a strong move in the direction that we wanted the court to go. One of the concerns is that, as Mario and Chris have stated, NEPA has kind of grown to be something and what it wasn't originally intended to be. The length of time it takes to get through the NEPA process, and the amount of analysis to litigation proof these EISs and EAs has really just ballooned, with the thousands of cases, right, that have been brought to all these different projects. So I think, a lot of the emphasis we had in our brief was to talk about that, to talk about, look, NEPA is, when it's overbroad, it impairs economic progress and it slows it down and, increases the cost and our ability to build quality infrastructure, the infrastructure that draws investments to, build out AI in our transportation system and our defense system and everything else. So yeah, we think one, it was a bit overreaching, and there should be more balance there and thought towards the economic progress side of it. And then the third point, which we brought up in our brief, was the major questions doctrine, and that what agencies were doing in being required to sort of claim all this authority to look at effects that were outside of their statutory authority was a sort of power grab, so to speak, a unauthorized, transformative type of power grab that is described in the major questions doctrine that agencies shouldn't do. So we thought the end result was a great decision, and hopefully will help right size the permitting process and get it back or closer to where I think it was originally intended to be.
Thanks, Chad. I'm sorry, go ahead.
Say, if I'm not mistaken, in one of the passages in Justice Kavanaugh's opinion where he talked about the negative economic impacts of endless NEPA delays, he in fact referenced the Chamber's amicus brief. So kudos to Chad and the authors of that brief.
Thank you. Thank you for mentioning that. I probably should have mentioned that to give to my teammates the kudos. I did have input and reviewed it, but I was not the author. But yeah, the team at the Litigation Center was really proud of that, to actually be referenced in the actual opinion. So that's and I was actually there at the oral arguments as well in December. So it's been interesting to see how this whole process played out.
So Chris Mario had mentioned the concept of deference and how that played into this decision. The word was mentioned 11 times by my count, and often preceded by the word substantial. That obviously led some commentators to question how 7 counties can be squared with Loper Bright. Mario talks a little bit about that as well. How did the court explain why substantial deference to agencies in this context is appropriate?
Yeah, everybody was curious how the court was going to. I think most of us expected the result that occurred here. Everybody was a bit curious about how the court would distinguish the Loper Bright doctrine, which said if there's an ambiguous statute, it's the job of the courts to figure out what the single best interpretation is, and nobody needs to pay attention to what the agency thinks the answer should be. Here, the project opponents tried to argue that what was going on here was the court needed to interpret the statutory term detailed, as in detailed environmental impact statement, and Justice Kavanaugh, and so that was a job for the courts under Loper Bright and not no deference to the agency required. Justice Kavanaugh said, no, what's going on here is the agency is making a bunch of fact-dependent, policy-driven choices about how to evaluate different environmental impacts and economic interest, and that is something that the agency is still entitled to deference over, notwithstanding Loper Bright.
Mary, do you want to add anything to that?
Well, I would say it's not that it's notwithstanding Loper Bright, is that it's that, the Section 706 has two different categories of that are relevant to a court reviewing an agency action, which is it a question of law, or is it a technical or policy judgment? If it's a technical or policy judgment, then it's held to the arbitrary and capricious standard, which is supposed to be one of substantial deference. If it's a question of law, then that's for the courts to decide. So there's a very clear sort of distribution, allocation of these of deference according to comparative advantage that's faithful to the Administrative Procedure Act. I mean, it is a little bit of it does make your head hurt a little bit, because, okay, so what agencies, what alternatives or impacts or how much detail does the agency need to study them in? The threshold question is, what does the word, impact or effects mean under NEPA? What does the word alternatives mean under NEPA? What does detailed statement mean under NEPA? But I don't think that the court can be expected to I don't think that courts, in interpreting that statute, can be expected to offer more than a general gloss. That's why when the agency comes back and says, we are studying these 5 specific alternatives, or we are studying, the following categories of impacts, the court says, wait a second, that's not, the Supreme Court, Kavanaugh says, that's not a question of law, that's a question that is within the technical competence of the agency, because the agency knows what is relevant to the decision maker. This is another thing that we maybe should touch on a little bit more. What's the kind of touchstone of why are we deferring to the agency on this? Because the purpose of NEPA is to inform the decision maker, and it's a technical question: what alternatives and impacts and how much detail is required to inform the decision maker. And so, but remember that he's saying we have to really substantial deference, but courts have been saying substantial deference on all this stuff since the 1970s. I mean, that's why Justice Sotomayor is like, yeah, substantial deference. It's always been substantial deference. There's nothing to see here. Anyway, so that's why I just think it's very important to, I just want to, I think that the part of this opinion that I hope lower courts really pay attention to is not the part that says substantial deference. It's the part that says we really mean it this time, substantial deference. Right.
So within that, continuing that conversation, when reviewing an agency's assessment of environmental effects and feasible alternatives for purposes of NEPA, Justice Kavanaugh wrote that the court should not, quote, micromanage agency choices so long as they fall within a broad zone of reasonableness. Chris, how do you think lower courts are going to read that term, broad zone of reasonableness?
Well, I like Mario. I hope they read it in a new way rather than in the old lip service to deference way. But Justice Kavanaugh's opinion was pretty firm about courts in the past paying only lip service and not, in fact, deferring. And on the issue of, one of the things that the Justice Kavanaugh's opinion also said is that the agencies should be given deference with regard to the length and detail and evaluations that they consider in the EIS is on top of everything else. So if you put all that together, I think it's going to faithfully adhere to what should be the APA arbitrary and capricious review standards to begin with. I think the lower courts should back off considerably. Whether they do or not remains to be seen. The early returns are a little mixed thus far.
So after noting the need for reasonableness review, the opinion laid out some of the consequences to infrastructure development of litigation caused delays, some of those that Chad was referring to previously. Chad, were you surprised that Kavanaugh seemed to go out of his way to note the impact on things like renewable resource development?
Yeah, it's not really, because there are situations where just about every project type has been impacted or litigated in some way or another. And as Justice Kavanaugh had noted, it's not always the fact that the people that litigate, the special interest groups, have the environment in mind. So projects of all types have been blocked or slowed down. And the real challenge is if you get a EIS kicked back to you because the court said you didn't look at a particular type of environmental effect, the delay associated with that can be extremely costly. I was listening to Politico's Morning Energy podcast a few weeks ago, and there was a project, offshore wind project, that was being delayed, and they were something like, $51 million a day in costs due to the delay. So there are all kinds of delays and costs associated with all types of projects, and it really does slow down. And just because of the delays and increased costs, it often blocks projects. So a more efficient, better NEPA process that really focuses on the agency's organic statutory authority will be a good thing for getting high quality infrastructure in the ground.
So the court then moved on to the question of whether agencies must consider environmental impacts of projects further in time and place. Mario, did you find the opinions reasoning on this sort of authority issue satisfying in terms of offering lower courts clear guidance?
Great question. I have to say that I found it less than satisfying because this does not seem to me like again, the decades-long search for some limiting principle on clear limiting principle, right, that agencies can understand on what upstream and downstream impacts they're supposed to study under NEPA goes back to, I believe it's Robertson versus Mythe Valley, one of the early 1980s Supreme Court cases that talk about a manageable line between those impacts that an agency should study and those impacts that an agency need not study. I don't think that the principled line here is, I don't think that this is, I mean, it may be manageable to say, well, impacts of a project that's removed further in time and space from the project at hand, we don't need to study that. That may be a bright line rule, but that's not really the principled principle that we have been searching for completely, because it's easy to imagine impacts that are just as far downstream of the project at hand and are just as higher order impacts downstream from the project at hand with the same kind of proximate causation analysis. But the intervening factor that should break the chain of causation is not a project, but something else, like development downstream, right? And so presumably now we have a rule that says that second part of the court's opinion is not going to be availing unless you can point to a project downstream and say that these impacts are the result of a project. And I'm not super clear how projects got in there. I don't think that project impacts of projects further downstream should be the basis for this. I mean, I will say one interesting thing is that the language about, and I think this was, what the Seven County Coalition went into the court asking for. Again, I think I mentioned this the first time around. Justice Thomas was sufficiently perplexed by this proposed rule that he asked the respondents to explain, because his several attempts to ask Paul Clement to explain had not helped him. What rule the petitioner is asking for. This language about further in time and place is specifically drawn from the CEQ regulation of NEPA definition of indirect effects, right? And that's very important because it's sort of, Kavanaugh doesn't mention the CEQ regulation of NEPA at any time, but if he had mentioned it, and if the court was still in a frame of mind of, CEQ has rulemaking authority, and so these regulations are something that we have to pay attention to, this would essentially have been a partial reversal of the CEQ regulation of NEPA, because it would have said, nope, even if it fits within this definition of indirect effects, if there's a project involved, it's not something that the agency has to study. And again, I just think that this part 2 of the decision is going to leave us still searching for this limiting principle. And I would just say that the limiting principle is really in the first basis of the court's holding, which we spent the first part of this webinar talking about, which is the question of deference and under what circumstances the agency is due deference on its judgments. And the line of deference has to do with the agency's jurisdiction and expertise. Why? Because nobody at STB knows anything about climate impacts. And so if STB is talking about climate impacts, that shouldn't be due any deference on the part of courts. And if it bases a decision on the consideration of climate impacts, then it is considering factors that Congress did not intend it to consider. And according to the Supreme Court's decision in State Farm, now we are potentially in the land of an arbitrary and capricious agency action.
Thanks, Mario. So during its analysis, the court mentioned several times that Surface Transportation Board possessed no regulatory authority over downstream and upstream projects that might have an environmental impact. Chris, do you see that as part of the broader remote effects analysis, or could that be a singular reason a court could rule against a NEPA plaintiff?
I think it may be a singular reason why courts could rule against an NEPA plaintiff, and I think it's at least a partial solution to the problem that Mario identified, that separate projects geographically or remote in time is a little bit squishy as a basis for deciding what effects need to be considered and not considered. But it's pretty easy to see what a lead agency has jurisdiction to regulate and not regulate. Here, the Surface Transportation Board didn't have authority to regulate upstream or downstream climate impacts. So, having it evaluate things it had no control over was sort of the epitome of pointless busy work. And I think that may be a good way to figure out what needs to be evaluated and what doesn't need to be evaluated, along with the pretty explicit rejection of reasonable foreseeability and but-for causation as tests for deciding what needs to be evaluated.
Mario, Justice Kavanaugh offered some intriguing dicta in his decision of whether a court should vacate an agency's approval of a project if the court finds the impact statement alone lacking. What impact do you see this having on future NEPA litigation?
Well, I think that this goes to a problem that has really been a long-standing one in agency in the procedural aspect of how courts have treated NEPA. Which is that since the 1970s, courts have, very unlike their treatment of environmental advocacy groups, right? They have rolled out the procedural red carpet for environmental advocacy groups. They've relaxed bonding requirements that would otherwise apply to a request for an injunction. All of these sorts of things, standing requirements. They invented the whole procedural zone of interest, procedural standing that under NEPA, which of course doesn't have a right of action, but they say we're going to say it has one under Section 706 if you're within the zone of interest. So they've really rolled out the carpet. But then what they haven't done, what they've given very short shrift to, is the public interest in effective agency action, right? And the public interest in the economic benefits of timely infrastructure decisions. And so especially because those equities are supposed to be weighed when considering an injunction, I think the message here was, first of all, courts, let's defer to the agencies on this, give to Caesar what is Caesar's, but also stop issuing injunctions for everything when you can when the issue in question can be fixed with a supplemental EIS. If it's not something, if it's not something that you can show would have changed the agency's decision, then it's not material. They shouldn't be material enough to give rise to an injunction. So we're limiting both. If this was really firing for impact, as they say in the military, if the courts really interpret this as a change, a sea change in NEPA, it'll be a significant restriction of the purview, right, of courts looking at a NEPA review, and also a significant restriction on the remedy side. And of course, there's something else which is related, which you may be about to ask about, which is he also pointed out that the NEPA review is not an agency action for purposes of the APA. It's just part of the agency action. And so even if there's an omission in the EIS, the relevant question is whether there's an omission in the record of decision. And that has a different standard than the standards that apply under the definitions of NEPA. And that's another very important, potentially important wrinkle, because, of course, agencies have applied Administrative Procedure Act arbitrary and capricious standards to the EIS as if the EIS was the agency action.
Chris, you wrote a little bit about this vacatur dicta in a piece for Bloomberg, and you mentioned that there was a past Ninth Circuit decision that took the type of approach that Justice Kavanaugh was talking about. Can you tell us a little bit about what the appellate court did there?
Yeah, there's a center. Well, there's a number of them, but including the Center of Biological Diversity opinion, which is just out, I think June 18th. So it was briefed and argued before Seven County, and then decided after. And they tossed in 4 or 5 quick references to Seven County, and among other things, did not decide that the agency rulemaking needed to be vacated. And I think that if that takes hold, that may be the most important thing that arises out of Seven County in terms of projects not being killed by delay, because it takes probably 12 to 15 months for a NEPA case to work its way through the district court, pretty much anywhere. If you're in the West, or at least in the Ninth Circuit, an appeal takes like 15 to 24 months to work its way through the system. So if the courts are still going to be vacating agency decisions and remanding for further proceedings in the district court, that's a 3-year delay in any project for what might be at most a procedural issue. And Mario's point, I think, is worthy of reinforcing, which is that the environmental impact statement is a document that the agency prepares to inform its decision on other things that are final agency actions as documented in a record of decision, like whether to issue a special use permit or something like that across public lands. The EIS itself is not a final agency action. So flaws in the EIS alone shouldn't necessarily require vacature and remand, but instead the court should look at whether the alleged flaws in the EIS will make a kind of a material difference in what the actual agency decision would be as reflected in the ROD.
Chris, you mentioned the decision by the Ninth Circuit, which involved the Bureau of Land Management approval of an oil and gas venture in the Northern Arctic. Have there been any other courts that have cited to or referenced Seven County since the court came down with the decision?
There's another district court ruling in Alaska on the Willow Creek oil and gas, which sort of referenced in passing Seven County pretty favorably. We have a case pending in the District of Arizona that will be in the middle of cross briefings for motions for PI, and the court took note in sort of a tentative ruling the day after Seven County that Seven County was out, and seemed to be an important case everyone should pay attention to. So it's, there aren't a lot of substantive results that have percolated long enough after Seven County to see if it's actually going to make a difference. I suspect it will have some beneficial impacts, but again, the proof will be in the pudding, as Mario says. If we go back to everybody citing Seven County for the proposition that we're supposed to defer to the agency, and then the courts doing what they've been doing for several decades anyway, and making their own policy choices, then we've achieved nothing.
Chad, one of the potential benefits of the decision, and Justice Kavanaugh did make some reference to this, is that perhaps federal agencies will reduce the amount of litigation proofing that they feel like they need to do when drafting these impact statements. Do you think that could be the case here? And is there anything that businesses who have a stake in these kind of EISs and the outcome of them can do to make sure that the agencies understand they don't need to do the kind of litigation proofing that they used to have to do?
Yeah, we're hopeful that from the business's standpoint, from an efficiency standpoint, that the EISs and EAs can be simplified, and to not have to look at the upstream and downstream effects, but really look at the project and the impacts there in time and place. Um, I think that from the business community perspective, it's tough, right? Because they have this long history of being litigated and or the agencies being litigated on projects that they often want to that project proponents want to build. And I think it's going to be hard to pull back from that and that sort of fear that if we don't cover that particular environmental effect, that it's going to lead to litigation. So that's what's led us to this point. Is that fear that, look, let's just cover it and let's just analyze it, because that's just one less thing that we may have the EIS push back to the agency because. So I'm hopeful that they'll be able to streamline the process and really focus on an agency's authority and the project itself at time and place. The Supreme Court or the federal agencies have won every Supreme Court case. What was it, 12 to nothing or 13 to nothing? Public citizen is another, it's one that's referenced back in this case as well. That NEPA is a procedural statute, and now hopefully this 7-county case really focuses it on the project itself and what the agency's authority is. And in the end, I hope that leads to a more efficient, better NEPA process.
So can you explain for those that may not be familiar with the two different forms, what's an EA versus an EIS?
Yeah, so if it's a major federal action and it's going to have significant environmental impacts, think of the big expensive projects, roads and bridges and offshore wind projects and natural gas pipelines and that sort of thing. Those typically require environmental impact statement, which is a lot more detailed analysis. Usually public meetings to get feedback from the public and that sort of thing. And in the past, they've been multiple drafts, right? It's been a draft EIS, go out for public comment, and then finalize an EIS. But for an EA, if it's found that there's no significant impact from the environmental effects, then the agency is able to issue a less complicated document that goes less into the details. It's supposed to be, cliff notes, so to speak, on the environmental impacts to get something done, more quickly. So those are two of the environmental documents. And then the third is the categorical exclusions, which are really supposed to be a one-page. Here it is. It qualifies, and your permit is you're authorized to go do what it is you want to do.
Have there been challenges filed against agencies for doing an EA when the plaintiff thought there should have been an EIS done, and is that going to sort of?
Oh my God, yes.
Okay, Harry, I'll let you expound on that, and whether or not this decision will have an impact on those kind of challenges.
Many such examples. In fact, I wouldn't be surprised if at any given time, Environment and Natural Resources Division of Department of Justice is litigating 35 cases along the lines that you just described. And I will say that this is, to what you and Chad were just talking about. I think there have been, the government has won every NEPA case, but the problems of NEPA have not gotten better, right? And so that's it's another one. And so I will say, I'll make 2 points here that I think are just important to make that I've been hoping we could get to before the end of the hour. One of them is that I think that what we have is an opportunity for CEQ to really step up. And I think we just had an announcement of a wonderful nominee to be the new chair of CEQ. This is an opportunity for CEQ to step up and say, okay, so we rescinded the CEQ regulation of NEPA because this somehow escaped everybody's notice for 40 years, but CEQ doesn't have rulemaking authority. But CEQ is still a component of the White House, so we still have directive authority. So we still have authority to be prescriptive as a matter of presidential administration in how agencies implement NEPA. And so CEQ can step up and say, one of the things that we're going to require agencies to do as a matter of presidential administration, not judicially enforceable, but just internal guidance for the agencies, is that agencies are going to treat this decision as if it really means what it says, and are going to treat this decision in the expectation that they will get deference to their determinations on impacts, alternatives, how much detail to study them in. And therefore, let's test this by saying, including appendices, no EIS longer than 150 or 200 pages. Let's just put real restrictions on this. That may make, I can understand if that'll make initially some of the project proponents nervous if they're the ones that are the guinea pig for this. But I think in fact, I'll go so far as to say that I'm confident that unless the administration pushes the envelope on this decision, it'll turn out to be nothing to see here, right? So I think that this was going to require taking some projects as guinea pigs, coming out with a grand total 150-page EIS that took 7 months to produce as opposed to 3.5 years, right? And then saying, okay, let's go to court and see what this opinion really means, because if on the basis of this opinion the lower court starts sustaining these significantly truncated EISs, that's how you know that you've really got something significant out of this opinion. I will say something else. Another point I wanted to make. I mentioned the Sable Trail case earlier at the top of the webinar. This is a DC Circuit decision involving the Sable Trail pipeline. It's Sierra Club versus FERC, I think, August of 2017, in the DC Circuit, in which the DC Circuit vacated a permit for an existing pipeline that's feeding natural gas to a Duke Energy power plant in Florida, because the FERC had not, according to the DC Circuit, had not sufficiently accounted for the potential power plant emissions of that power plant, which is right? I mean, that is a project further removed in time from the project at hand, which is the pipeline, right? And so Justice Sotomayor in her concurrence says, so the reason I bring up Sable Trail is that one limitation on everybody went into this 7-county case trying to ride the public citizen horse as hard as possible, right? But public citizen says where the agency's action has only a limited statutory authority over the action, it can't be required to study the impacts. Well, in the limitation there, and here was the strongest grounds for the DC Circuit's opinion, is that's a somewhat sui generis situation, right? In that situation, the agency and public citizen, the agency literally had no discretion whatsoever. If the president decided to allow Mexican trucks to cross the border from Mexico, the Department of Transportation had to issue safety regulations. So therefore it didn't need to study the impacts of safety regulations that it was required, 100% required to issue. Well, so what was the difference in this case? In this case, you have very broad statutory authority. Actually, it's hard to imagine any statutory authority broader than a certificate of convenience and necessity, which is couched in terms of, early progressive sort of rule by technocrats rather than democracy. That is very expansive and very capacious. And Sotomayor said, nothing to see here, because downstream, whatever convenience and necessity means, it doesn't mean these downstream impacts. Well, funny she should say that, because convenience and necessity is not just the Surface Transportation Board's authorization, it is also FERC's authorization under the Natural Gas Act for pipelines, right? And so unless public convenience and necessity means something different under STB jurisdiction than it means under FERC jurisdiction, then it seems clear that this court has implicitly, even under Justice Sotomayor's nothing to see here concurrence, that this court has implicitly overruled the DC Circuit's decision in Sable Trail. And so, anyway, I think that's an important point that people should consider moving forward as well.
Thank you, Mario, for adding that. Chris, any thoughts on what Mario was talking about before we move on?
Well, I'm still cautiously optimistic that this will make a difference in court review of NEPA cases, and I do think that the courts are going to be hard pressed to ignore public citizen, if not extend it, and stick to the proposition that NEPA is a procedural statute to begin with, and it would be doubly pointless busy work if agencies were required to evaluate environmental impacts that they have no authority to regulate, and which by definition cannot form a basis for their final agency action, whatever that is. So hard to believe that this could be the case, but Mario seems to be even more cynical and pessimistic than I am about the future of NEPA litigation after this case. So I'm going to at least hold on hope for another several months until we see what the first wave of cases more fully considering Seven County turns out to look like.
But I'll just add, I mean, to my point on I think CEQ's role in stepping up here, Chris, wouldn't you agree that if in the months ahead agencies continue to put out these 1,000-page EISs, do you agree that we have lost the opportunity to translate this decision into a meaningful improvement in NEPA practice?
Well, maybe. I think, well, first off, I don't think the courts care anymore what CEQ's interpretation of NEPA is, and probably there are independent agencies that do have NEPA regulatory authority in areas where CEQ does not. I'm not sure that their regulation and guidance are going to make much difference to courts either. I do think that if administrative agencies treat this as a watershed decision that is an excuse to dramatically reduce the sprawling typical EIS, then that may help enhance briefer judicial review. It's going to be hard to pull that off, though, and of course, we've had a series of both Democratic and Republican administrations going back to 1978 have said, NEPA takes too long and produces these long documents that say everything and in a sense, accordingly, say nothing. So let's make them shorter. And the first Trump administration called for page limits. I think it was 150 for environmental assessments and 300 for EISs. And those got promptly ignored, or everything got shoved into an appendix. So you had not only a 300-page narrative and 2,700 pages of appendices, you also had for environmental impact statements that were in the middle of being written when this guidance first came out. You had this odd situation where a third-party contractor was essentially done with an environmental impact statement being written on behalf of an agency. It was 3,000 pages long, as was typical. And now the agency was telling the third-party contractor, well, you need to go make this 300 pages instead of 3,000. And of course, the net effect of that was producing yet more delay as a consequence of attempting to honor guidance that was supposed to eliminate delay. I'm skeptical that agencies will be able to immediately change their habits. So it may be a little slower progressing than we would like to see. I also think it will help if some of the earliest opinions from the district courts sort of enforce Justice Kavanaugh's opinion in its full spirit, and heartily reject nitpicky NEPA challenges. That, I think, will lead agencies to feel a little bit more comfortable with, say, A 2,000-page EIS for starters. Let's make it a third shorter than is typical and see how that flies.
Can I respond to that just very briefly?
Sure.
Good. So I just want to say that, I think that courts, I have always said that courts should not be paying attention to anything that CEQ has to say, whether it calls it a regulation or not, because it's internal to the administrative branch, to the executive branch. But agencies have to pay attention to what CEQ says. Executive branch agencies have to pay attention to what CEQ says, because CEQ is a component of the White House. So it exercises presidential directive authority. When a memorandum from CEQ to agency heads is like a memorandum from the head of the National Security Council to agency heads, right? And so I think that it's very important for CEQ to exercise this authority here, because unless you have all agencies on the same page about what this decision means in terms of new standards for producing EISs, then you're going to have some agencies producing 150 EISs and other agencies still producing 3,000-page EISs, and the 3,000-page EISs are going to make the 150-page EISs look insufficient. And this kind of heterogeneous approach across agencies, it will really weaken and get everybody back. I mean, it'll greatly strengthen the case for business as usual, and that's why I think that for maximum impact, CEQ is in a unique position to say, okay, permitting agencies of the federal government and FERC and NRC, we hope that you agree with this. But executive branch agencies are hereby directed to apply this decision in the following way. And we're going to produce, a uniform standard EISs that are short, and in which every EIS contains a affirmation at the beginning that the agency has determined that its alternatives and impacts and the detail that they need to be studied in are due deference from the courts under this decision. I mean, I think that that's necessary in order to translate this decision into agency practice, because if agencies left to their own devices are highly likely to just go on with business as usual.
Yeah, and I think. Oh, sorry. I just respond briefly to Mario's point. I guess we've seen that sort of CEQ administrative mandate to agencies in the past, and it hasn't stuck. Maybe the issuance of 7 county in combination with a renewed mandate to make it pithy will work this time. The other thing that I think will give project proponents concerned about the guinea pig aspect that Mario has mentioned a little bit of comfort is if we get out of the business of assuming that every time there's a NEPA violation, the agency action needs to be vacated and remanded. That will help a lot, because that way it's not a automatic 3-year delay if there's a flaw in the EIS, but rather the agency goes back and fixes the document, but there's not a massive disruption in the project schedule. So that maybe the combination of those 3 things will work and produce the effects that Mario would like to see, which I definitely share.
So talking about federal agencies, Chad, under an executive order, federal agencies were asked to craft NEPA regulations within the next 12 months. How do you think that's going to play forward now that the Supreme Court's issued this decision?
Yeah, let me go back just a little bit to set the stage for sort of where CEQ is today. Because, day one, executive order, the president issued the Unleashing American Energy EO, which said expedite permitting, right? In particular for energy, domestic energy projects, and requested recommendations, I think, within 30 days from agencies on what they can do to expedite that. CEQ followed up with a memorandum in February to agencies on how to develop their NEPA procedures. A few days later, they issued an interim final rulemaking that essentially rescinded CEQ's regulations. And then in April, they issued a template to agencies and other guidance saying, here is a template for when you go back and look at your NEPA procedures, here's what you can do. Here are things that you can look at. Now, they're very careful in that memo to say this isn't binding. This doesn't need to restrict what you can or cannot include, but here's an idea for you for how to go about updating your NEPA procedures and methodologies. And they sort of made that shift from, going from issuing regulations and updating regulations to being very clear that, look, the statute says agencies can issue procedures and methodologies, so that's what we want you to do. And here's a template for getting that started. So I think you have a combination of all these different things, and we're really excited to see the administration taking these bold moves to try to get the permitting process right-sized, to get it expedited, so that, in energy and everything else, we can build the quality infrastructure we need to grow our economy, create jobs, and bring the benefits to our communities.
Where does the decision fit into the larger effort on the Hill to try to advance legislative reform to the permitting process?
Yeah, I think Chris and Mario have both highlighted some of the questions, and if you start digging into this, the uncertainty that still exists. And it just calls upon Congress to fix the broken process and to provide more clarity to it, to ensure that NEPA is the procedural statute that it was intended to be, and to balance, this economic development with NEPA and the permitting process. So we're hopeful that Congress will take this up, do something this fall after the reconciliation process is wrapped up, hopefully by July 4th, and really get on it, because if you talk to folks on the Hill, there really isn't a constituency that doesn't want to build something and a lot of something. So there's a lot of momentum there to get something done. We just need folks to get together, make the compromises, and make this process more efficient, transparent, and better.
Thanks, Chad. I can't end the program without asking Mario this question. So in footnote 2, Justice Kavanaugh notes, some have debated whether Congress and the president in 1970 actually intended or anticipated judicial review of agency compliance with NEPA. Did he put that in there for a reason?
Well, sure, because they would have heard, especially from several amici pointed out, and I mean, people talk about this all the time. If he reads the Wall Street Journal or any popular article on NEPA, people will point out that NEPA does not contain a right of action. Not only does it not contain rulemaking authority for CEQ, which somehow escaped everybody's notice for 40 years, it also does not contain a right of action, which has escaped everybody's notice only because in the 1970s, the court said, well, if an agency, the theory of procedural standing, right? And the zone of interest of that's supposed to be protected by a particular procedure. Court said, well, yeah, okay, but this is supposed to protect people that are potentially affected by the environmental impact. So we're going to say that they have procedural standing to bring a challenge to the agency action under NEPA. I think that this is, I think that he let sleeping dogs lie here, because that would really blow up NEPA to say that, in fact, there's not a right of action to enforce it. By saying our cases have right, he didn't say, no, that's not correct. So NEPA does have a right of action. He just said our cases have recognized a right of action to enforce NEPA. And so I think that the most that you can make of that is that he has let stare decisis stay decided.
And he did add at the end of that footnote, that said, courts must conduct their review with significant deference to the agency. So it gave him another opportunity to use the term significant deference, which I found was interesting. But we are at the end of our time. Gentlemen, thank you for joining us a second time in the last 7 months to talk about this decision. Hopefully everyone heard what they needed to hear and enjoyed what they heard. you have an opportunity to do a survey right after you log off of the program, we definitely would appreciate that. Chad, Chris, Mario, thank you again for joining us today.
Thank you all.
Thank you all.